So a client recently asked me an interesting question about the pros and cons between a will and a trust. And in order to fully understand the pros and cons between each, we have to first understand what each document is. With a will, this is a legal written document that disposes of a person's assets at the time of their passing. Now, in general, a will is going to designate someone to manage the estate at the maker's passing. In some states, that's called an executor. If it's a female, it's an executrix. And in some states that have adopted the Uniform Probate Code, that term has been changed to a personal representative. Now, a personal representative or an executor of the estate is going to have a fiduciary duty to the estate to ensure that all of the debts are effectively paid and all of the assets are distributed the way that the maker wanted them to go at the time of passing. With a will, in order to have a valid will, the maker has to be over the age of 18 and of sound mind, have to be a competent individual. The will also has to be witnessed in general, or it should be witnessed in general, by two disinterested persons. Now, the Uniform Probate Code has changed that a bit. If a witness is an interested party to the estate, so in other words, if the witness is receiving any assets from the estate, then that witness is basically wiped out of the will as if they never existed. So it's always recommended that the witnesses are disinterested parties. Now, also when it comes to the signing of a will, it's recommended that the will be notarized by a notary public. And the reason being is if there's a self-proving affidavit, then in many instances, the will does not have to be proven by testimony of witnesses to the will if the will is introduced to the court. Now, with respect to a trust, what is that? That is a fiduciary arrangement between individuals in which a maker of the trust will appoint a manager of assets or entrust assets to an individual or individuals called trustees or managers of the assets for the benefit of others, and those others would be called beneficiaries of the trust. Now, usually your trusts are in writing, and they are going to be funded as the maker deems fit. They can be funded during the maker's lifetime, or they can be funded at the time of the maker's passing. But in any event, a trust is typically a document that goes into effect as soon as it's signed. Now, in general, there can be two types of trusts. The first type of trust is what I usually will phrase to people as, or clients as, a flexible trust. And this is called a revocable or revocable trust. And with this type of a trust, the terms itself inside the trust can be changed, the people involved in the trust can be changed, and the assets can be changed. And in general, when it comes to flexible trusts like this, we also phrase a nominee trust as being the type of document that a trustee has the ability to act at the direction of the beneficiaries. Now, with flexible trusts, the maker can be the trustee of the trust or the manager of the asset. The maker can also be a beneficiary of this type of a trust. The second type of trust in general that a person can make is called an irrevocable or irrevocable trust. And with an irrevocable trust, the terms are very rigid and are not easily changed. Normally, the folks that are trying to interpret or manage the trust have to look to the terms inside the trust to see how things are supposed to happen, whether changes to the terms can be made, whether changes to people involved can be made, or whether changes to assets can be made. But typically they're very rigid, and most terms in persons and things inside the trust cannot be changed. Now, you also heard me mention a couple of times the word fiduciary. When it comes to being a fiduciary, this means that an individual that's appointed has a high level of trust associated either with the estate that's being handled or the assets that are being managed by some type of a trust. And this person that's appointed as the manager whether it's for an estate or for a trust, can be held liable if they do not act in accordance with the terms or the direction of the maker of the instrument. So let's get back to the question, the pros and cons between a will and a trust. Well, first of all, let's take the will. Some of the benefits of having a will. A maker of a will can specifically designate assets to individuals inside their will. So in other words, they can make what we call specific bequests to individuals. That's one general benefit. Another benefit is a maker can exclude an individual from their estate, specifically exclude the individual if they wish them not to be involved in the estate or to receive any assets from the estate. Now, if there are minors or individuals that need further assistance with themselves or their assets, when it comes to minors, first of all, the will designate, or the maker will designate, a guardian inside the document itself to care for the person of the minor for their care and well-being. The everyday, day-to-day care of that person will be designated in the will, in other words. Also inside the will, there can be a trust inserted inside the will document that will be introduced to the court eventually, right? And that trust is called a testamentary trust. And why would someone put that testamentary trust? Well, once again, for a minor in a situation with a child, assets cannot be left to that child. So the will designate a trustee, and that trustee will hold the assets for the minor until a designated age, some age over majority, some age over the age of 18, could even be at the age of 18. But in any event, there will be court oversight of both the person of the minor and the assets involved in the estate. Now, when it comes to an individual that needs further assistance or may be incompetent, once again, that testamentary trust would come into play and assets would be held for that individual until they're either better or until they're passing. Now, when would that be an issue? Well, in most instances in my practice, where I see it, is where we have a healthy spouse and a spouse that might be suffering from dementia. And the healthy spouse would make a will for themselves in which they would put a testamentary trust inside their will. And the reason for that is the assets would be handled on behalf of the spouse that's suffering from dementia, the ill spouse, until their passing, if the healthy spouse passes away first. Those assets would be held up inside the testamentary trust, and they would be held for the care and well-being of the individual or the spouse that's suffering from dementia or is ill in some other way. This could be good for the spouse that's suffering from dementia or some other illness if that person is receiving benefits, whether it be from Medicaid or Social Security. In any event, a testamentary trust is an effective tool in that instance. So those are some of the benefits of a will. Now, what are some of the cons or the downfalls of having a will? Well, once again, we've got the oversight of the court and the expense associated with that. There may be lawyers that are involved, and legal fees, and court fees. And whenever there is court oversight and legal fees associated, things could get complicated, more complicated than they need to be. And managers of the estate, the personal representative or the executor, may have to check in with the court on a periodic basis to do an accounting. So there could be additional expenses down the line. Now, on the trust side, what are some of the pros or some of the benefits? Well, first of all, a trust is a document, as I mentioned before, that's going to go into effect as soon as the maker signs it. And so right away, whatever assets held in that trust, the manager or the trustee is going to be able to deal with that asset on behalf of the beneficiaries. So that's one benefit. Also, if there are many people involved in a particular situation or with a particular asset, a trust may be a good document or a good way to effectively manage that asset with everybody involved. Now, what other types of benefits do you receive from having a trust? Well, Every trust is going to avoid probate for the most part, unless there's some other challenge down the line from one of the beneficiaries or someone who has an interest in the situation. Then there might be some court oversight. But in general, your trusts are going to avoid probate. Also, a trust can be an effective tool for estate planning purposes if a person wants to plan for Medicaid, as I mentioned before, or plan for estate taxes. So a trust can actually reduce the value of someone's estate so that estate taxes may not be needed to be paid down the line. In addition, flexible trusts or revocable trusts can be changed without notice to the world. Terms can be changed, people can be changed, and assets can be changed inside that trust. So that's an effective way to, once again, avoid probate and to handle assets. Now, what are some of the cons that you can have or can happen as a result of having a trust? Well, first of all, a trust can be complicated in and of itself. It can cause confusion. When it comes to irrevocable trusts or trusts that are not flexible, that can't be changed, banks don't generally like those. And so if there's especially real estate that's going to be refinanced, banks will not refinance while the property sits in an irrevocable trust. So it can cause confusion. Also, tax benefits can be lost. And what I mean by that is if there's an irrevocable trust, let's say there's a home that a person lives in and they put it into an irrevocable trust, well, that house is effectively separated from their estate. And if that house is sold while the maker of the trust is alive, there could be a loss of capital gains benefits. In addition, if that person is receiving some type of a tax benefit, whether it's a residential tax exemption, sometimes if they place it into an irrevocable trust, they lose that tax exemption, which could be substantial loss. So those are just some of the cons of having a trust. What's right for a person? Well, that depends on the situation. Depends on when they come in the door and what they're looking to do and what their final objective is. And that's some of the homework that I do in my practice. Now, if you're watching me on YouTube, make sure that you subscribe in the lower right-hand corner. If you're watching me on Facebook, make sure that you like the video. Be sure to check out some of the links that I've included down below in the description of this video. If you're watching me on YouTube, a lot of times if you're watching me on Facebook, it's above. And on YouTube, some of my prior videos are going to be appearing here. There'll be a list that will be related to this particular video, so make sure you check those out as well. Many of them are short and meant to be definitions. So make sure that you watch there and continue to follow me wherever you're watching me. Dave Ceruolo, CeruoloLaw.com.